How to answer the petition when you're sued for debt. Brought to you by Kenneth Chabert at yourlegallegup.com. Your advantage if you're being sued by debt collectors. Okay, today we're going to show you how to file the answer to a petition. For the purpose, we will use a simple petition that a client of mine received a few years ago. Yours might look just like it. Here's the petition. It was only a page long. It also had 2 exhibits, which I'll show you later down below in a minute. First, notice what the petition says and what it does not say. It doesn't say much of anything. What it does not say is that the debt collector owns the debt. It does not attach a contract or state any terms of a contract. And notice that it requests interest of 39% on the amount supposedly due. I emphasize that as sloppy as this document is, and you're going to see what I mean, it's very typical. Debt collectors are like bad factories. They don't look at what they're sending out, and they don't have the documents that they would need for the petition to be a legitimate use of the court's power. Okay, so how do you answer something like this? From the very beginning, you have a strategy decision to make if your petition, like this one, left out something as basic as ownership of the debt. Because the statement will have another company's name attached to it, right? That's how you know it's a debt collector. Instead of answering at all, in most jurisdictions you could just file a motion to dismiss. In that motion, you would simply argue that a petition that does not even allege a right to collect, remember the statement was from MasterCard or from a bank, does not say enough to state a claim, that is, give them a right to sue you for money. And you should win that motion every time. It's easily fixed, though, and the court would let them fix that by using what's called an amended petition. They would just file a substitute petition. So the question you have right from the beginning is, how tough do you want to make it for them? In general, I suggest that you make it very tough as possible for them. But there is a price to pay in your time, too. If you bring a motion to dismiss, whether you win or lose, you will slow things down by at least a month and probably more, which is probably a good thing, because it costs them money and delays their hopes of payment. And of course it puts off the day you would ever have to pay, either to settle the case or, in the very unlikely possibility, if you lost. But this case already looks very good. Let's say you do file a motion to dismiss. See the notes below for a hyperlink for a sample of that. Let's assume that you won your motion to dismiss and force the debt collector to file an amended petition, which says the debt collector bought the debt from someone else and owns it, but doesn't change the petition in any other way. But what if you lose the motion to dismiss? No problem. The court will give you some period of time to file an answer. In that case, you've still delayed the case legitimately. And you've cost the other side time and money, even if you lose the motion, which in this example you shouldn't. But I'm not suggesting you file bogus motions. That would cost you some of the judge's respect. But in this case, whether you win the motion or not, you'll probably win some of the judge's respect, and some from the other side, because you'll be giving everybody a tougher time, and you'll be showing that you know what you're talking about. And in this case also that the debt collector doesn't. But now you're going to answer the petition. When I represented clients, I would normally skip the motion to dismiss stage because it was too expensive for my clients, and it would delay what I considered our inevitable victory. But it's different for lawyers. To answer the petition or file a motion to dismiss, you need to file something called an entry of appearance. That is a very simple document that announces that you are going to represent yourself. See the notes below for a sample entry of appearance. You will file this along with either your motion to dismiss or your answer. You only have to file the entry of appearance once per case. And now, at last, the answer itself. Look at the first allegation. 1. Plaintiff is a limited liability company duly organized and existing under and by virtue of the law. You don't know whether or not this is true, And amazingly, you can't take it for granted. They do sometimes file suit without having the legal capacity to even go to court. So you say, 1. Defendant is without knowledge of the truth or falsity of this claim and accordingly denies. It is often not enough to say simply that you don't know. You have to deny as well, which it's your right to do. Now let's look at paragraph 2. That defendant is a resident of XX County, state of XXX. You do know whether or not that is true, and you admit or deny accordingly. It depends on where you live. Let's say they got that right this time, but don't take it for granted. Check. So that's an admit. On to allegation 3. That defendant is in default under the terms of the documentation attached hereto, incorporated herein, and marked plaintiff's exhibits A and B in the amount of 1332.14. Remember what the documentation is. At best, it's a statement. Possibly, but by no means always, the last statement of an account that you had before the original creditor charged off the account from, let's say, a credit card that you used to have. A lot of times these statements are completely fabricated, that is, made up by the debt collectors from electronic records. They never existed from the original creditor at all. You're going to want to find that out in discovery, which we'll talk about later. What do you say now, though? You say, deny. Why do you deny paragraph 3 even if you think you recognize the account? You can truthfully deny it because you are not in default under the terms of the documentation attached. What does that even mean? Nothing, really. The documentation that would establish any terms would be a contract and not a statement. And the documentation that would establish a default would be some kind of final statement. The debt collectors never attach these things. And if they did, they would have to allege that you never paid it off, and that would involve proof that they don't have. The debt collectors never have these things when they file the suit, and a lot of times they can probably never get them, no matter what, no matter how hard they try. Again, consider the documentation attached. We'll come back to this in the section on counterclaims. You can also deny the allegation because of the amount they claim you owe. You don't know that amount is legitimate. And there's another reason you can deny the allegation, and maybe it's the most important one of all. Just because you can. It's the plaintiff's job to prove its case, and it is not your job to admit their case. Okay, on to paragraph 4. That plaintiff has performed all conditions on its part required to be performed. And your response? 4. Deny. No mystery there. This is a meaningless allegation. Plaintiff is a debt collector, and there were no conditions on its part that were required, except ownership of the debt, which here they don't actually claim. The person or company who would have had conditions would have been the original creditor. Take a look at my article, In the Shoes of the Original Creditor, linked below for more on this. We'll also come back to this one in the section on counterclaims, too. Now for allegation number 5, that demand for payment has been made and payment refused. And the answer is, yet again, deny. In Missouri, at least, this allegation is a mere formality and is unnecessary. I'm sure that's true in most jurisdictions because the petition itself is considered a demand for payment if no other demand has been made. You might think that requiring a demand to be made would be a way to reduce lawsuits, but that part's been forgotten. But it's meaningless now, so why do you deny it? Again, because you can. And you hope the debt collector will spend some time and money trying to get proof that they already made the demand. Remember, they don't start off with that proof. They got to go get it if you make an issue of it. And the more time they spend chasing the case, the sooner they will decide to drop it and quit and leave you alone. Never let them see a light at the end of the tunnel if you can help it. So now that you've answered each allegation in the petition, you also answer the wherefore clause. That's where the debt collector says, wherefore plaintiff prays, ... You say, wherefore defendant prays that the court will give him or her, that is you, judgment against the plaintiff. and that the plaintiff shall depart with nothing, shall pay defendant all costs and expenses, and for such other relief as is just in all the circumstances. That makes it nice and legal sounding. And remember the language in that wherefore clause too, where they ask for attorney's fees and interest of 39%. We'll come back to that in the section on counterclaims too. So now look below to see what the final answer will look like. Protect what's yours and don't let the debt collectors rip you off. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but as a former lawyer I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. Get my litigation manual and forums, or get the videos and defend yourself. You'll be glad that you did. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forums. If you appreciate this video, please take a second and like it, subscribe, and friend me, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors on Facebook or YouTube, as these things help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.